Prosecutors filed more than 500 cases involving machine gun-style weapons during that time.
Recognition of tribes and have really enhanced the sacred trust that we have with Native Americans.
This is the most popular handgun in the United States that was purchased is the Glock 19.
Today, we honor them, their trauma, and their loss.
Illinois rifle and mag ban. The Supreme Court's got a hot potato on their hands. They're diving into a case that's got everyone talking. Illinois has these strict rules about rifles and mags, and some folks aren't too happy about it. So they took it all the way up the legal ladder, and now it's landed smack dab in front of the big shots at the Supreme Court. What's the beef? Well, it's about the legality of Illinois saying no to certain rifles and mags. The Protect Illinois Communities Act lays down the law, slapping restrictions on these firearms. But, and here's the kicker, there's a bunch of folks arguing that these rules aren't playing fair. This case is called Calkin versus Pritzker, and it's got more twists than a roller coaster. Calkin and crew are saying, hold up Illinois, you're crossing the line here. They're challenging this PICA Act, waving their legal flags and shouting, unconstitutional Second Amendment rights. Why is it such a big deal? Well, imagine you're a gun owner in Illinois, and suddenly the state's telling you what firearms you can and can't have. That doesn't sit right with a lot of folks, especially when it comes to their Second Amendment rights, the whole right to bear arms gig.
He should be respected.
Reclaiming my time. So, Mr. Chairman, I'd like 40 seconds
I've seen
back on
my
the clock.
constituents die in battle.
Bill was written with constitutionality in mind. It was based on bills in other states where the same ban has been upheld.
American Progress employee was to reduce gun violence, getting assault weapons, AR-15s.
Prosecutors filed more than 500 cases involving machine gun-style weapons during that time.
So here we are, the Supreme Court's up to bat, trying to figure out if Illinois is overstepping its boundaries. They're looking into whether these restrictions on rifles and mags are fair game or if they're stepping on people's rights. Think of it as a legal showdown, Illinois standing firm, saying their laws are for the greater good, and Calkin's team waving the flag of freedom, arguing that these rules go against what folks should be allowed to do under the Constitution. The court's got a lot on its plate. They've got to weigh the state's need for regulations against citizens' rights. It's not just about rifles and mags. It's about setting a precedent, about where the line gets drawn between safety measures and personal freedoms. And here's the kicker, it's not just about Illinois. This case could set the tone for how states handle gun laws across the whole country. So, yeah, no pressure, Supreme Court. But hey, it's the legal drama that's got everyone buzzing. Will the Supreme Court give a thumbs up to Illinois' rules, or will they send them back to the drawing board? The gavel's in their hands and the whole nation's watching. New evidence reveals judicial corruption. Hold on to your hat for this bombshell. So picture this legal drama. There's a case heating up in Illinois about rifle and mag restrictions. Calkin's team, pushing against the Protect Illinois Communities Act, claims it's a breach of rights. But wait, it gets juicier. Fresh evidence just waltzed into the courtroom, shining a bright light on some serious hush-hush dealings. Turns out, two big-shot judges at the Illinois Supreme Court might have had their pockets lined, and we're not talking spare change here, we're talking major campaign contributions. These judges, Rochefort and O'Brien, allegedly got handed a cool chunk of change from the same folks defending this rifle and mag ban. We're talking millions, not pennies, all kept hush-hush, like a secret treasure chest of cash. Now let that sink in. Judges who are supposed to be impartial, making decisions that affect everyone, might have had a not-so-small incentive to lean a certain way. It's like finding out your referee at a game got a wad of cash from one team's coach before blowing the whistle.
Automatic, 3-round burst, or semi-automatic. Those firearms are not allowed for purchase in the United States today.
Court where the last two justices that were elected benefited greatly from political contribution.
They don't care about that fundamental liberty law-abiding citizens in this country enjoy.
Every town, everywhere, people all over this country.
The plot thickens because these contributions weren't just from any old folks, it's from the defendants directly involved in the case. Conflict of interest, anyone? The worry is that these hefty contributions could have swayed their decision-making, the legal equivalent of wearing biased glasses while judging a case. And here's the kicker, despite Calkins' team raising a red flag saying, "Hold on, these judges might not be playing fair." The Illinois Supreme Court slammed the door shut on disqualifying them. It's like the judges giving themselves the green light to keep on trucking, even with a cloud of doubt hanging over their heads. This isn't just about a case anymore, it's about the integrity of the legal system. It's about ensuring that justice isn't swayed by hefty contributions and backdoor dealings. Imagine your favorite sports team losing because the ref was on the payroll of the other side. That's the kind of outrage boiling here. So now, with this new evidence shining a glaring spotlight on potential judicial bias, the whole legal scene's on edge. Everyone's waiting with bated breath to see if the Supreme Court steps in and says, "Hold up, this ain't right," because if they don't, it's not just Calkins' case, it's about trust in the system itself. Calkin versus Pritzker background. Let's dig into the heart of this legal whirlwind. Calkin versus Pritzker. It's not your run-of-the-mill case. It's a showdown over the Protect Illinois Communities Act, better known as PICA, and trust me, it stirred up quite the hornet's nest. Here's the deal. PICA isn't your friendly neighborhood law. Nope, it's got claws. It slaps restrictions on firearms, saying, nope, you can't have that rifle or that mag. But, and here's the kicker, Calkin and the gang aren't nodding along to this tune. They're waving the legal flags, shouting, "Hey, this ain't constitutional!" What's got everyone's ears perked up? Well, PICA isn't just any law. It's a game changer with an impending deadline that's got gun owners in Illinois sweating bullets. The clock's ticking down to January 2024, and if you've got certain firearms, you're supposed to register them or kiss them goodbye. Calkins' team is saying, "Hold your horses, Illinois, this ain't fair play." They're arguing that these restrictions stomp all over folks' Second Amendment rights. You know, that whole right to bear arms thing.
This is the most popular handgun in the United States that was purchased is the Glock 19.
Tweeted, quote, "Pass universal background checks and ban assault weapons and high-capacity magazines."
Is it the point of the bill to ban weapons that are in common use in the United States today?
I'm going to read you, so you can still, after this bill passes, you can own an actual weapon of war.
So here we are with Calkin facing off against the PICA Act. It's like a legal tug-of-war between safety regulations and personal freedoms. The stakes? Well, it's not just about rifles and mags. It's about setting a precedent. How far can a state go in regulating firearms without stepping on constitutional toes? Imagine you're an Illinois gun owner. Suddenly, the state's telling you what you can and can't have. That's what's got Calkins' team fired up. It's not just a legal tango. It's about principles and rights, about where the line gets drawn between keeping people safe and keeping their freedoms intact. And here's the kicker. This isn't just about Illinois. This case could set the tone for how states handle gun laws across the whole country. So yeah, the legal world's got its eyes glued to this one. It's not just Calkins' fight, it's a battle that could ripple across state lines. State court rulings and appeals process. Here's how this whole shebang played out in the courts. The lower state courts, those ground-level legal folks, they took a look at the PICA Act and said, "Nah, this ain't playing by the rules." Yep, they deemed it unconstitutional, waving the flag for personal freedoms and giving a thumbs down to Illinois' restrictions on rifles and mags. But hold your horses, that's not where the story ends. Illinois wasn't about to take that ruling lying down. Nope, they hollered, "We're taking this to the big leagues." So they packed up their legal arguments and marched straight to the Illinois Supreme Court, aiming to turn the tide in their favor. Picture this like a game of legal chess. The lower courts make their move saying, "PICA's out of line," but then Illinois plays their ace, the appeal to the bigwig Illinois Supreme Court. Now here's where things get twisty. The state Supreme Court isn't exactly nodding along to the lower court's tune.
Round comes out of the weapon just because you don't like the way that they look, because they function exactly the same. Now move this one over one.
It's more to us because we know the impact. We know how it impacts our families and our communities.
Recognition of tribes and have really enhanced the sacred trust that we have with Native Americans.
And guess what this bill will do? It won't make communities safer. Won't make them safer at all. In fact,
nope, they flipped the script. Instead of agreeing that PICA was a no-go, they leaned the other way, giving it the green light, saying, "Yep, Illinois, you're good to go with those restrictions." It's like a legal ping-pong match. One court saying unconstitutional, then the higher-up saying, "Actually, it's all good." And in the midst of this back and forth, Calkins' team is left scratching their heads, wondering how the game turned against them. This isn't just about a law anymore, it's about the game of legal interpretation. What one court saw as overstepping boundaries, the higher-up saw as fair play. It's got everyone questioning where the lines are drawn in the sand, what makes a law tick or get the boot, and who gets the final say in this legal tango. But here's the thing, Calkins' team isn't throwing in the towel just yet. Nope, they've got their sights set on the Supreme Court of the land, aiming to shake things up and get a different kind of verdict. It's a legal tug-of-war that's got everyone on the edge of their seats, waiting to see how the big shots at the top will call the shots. Conflict of interest. Well, hold on to your legal hats for this one. Here's a twist that'll make a soap opera jealous. Those two Illinois Supreme Court judges, Rochford and O'Brien, might have had a bit more than their legal robes going on. We're talking about some pretty hefty campaign contributions slipping into their pockets, courtesy of the very folks they were supposed to be judging. Yep, you heard that right. The same defendants tangled up in this whole rifle and mag ban mess. They allegedly reached deep into their wallets and made it rain, campaign contribution style, for these judges. And we're not talking a couple of dollars slipped under the table. We're talking about some serious cash, enough to make folks raise an eyebrow or two. Now here's where the eyebrow raising gets serious. These judges, the ones getting the dough, they're the same ones supposed to be weighing in on the legality of these rifle and mag restrictions. See the problem here? It's like having the fox guard the henhouse. The worry is, can these judges really make an unbiased call when they've had a shiny bag of cash tossed their way? It's got everyone squinting their eyes and asking the big question. Can these judges truly be impartial, or has their judgment already been swayed by these sizable contributions?
Today, we honor them, their trauma, and their loss.
I believe we have too much gun violence in this country.
Sure. I get that. I just
Take meaningful steps towards curbing the unacceptable gun violence on our streets.
Calkins' team naturally is waving the red flag, shouting, "Hey, this ain't fair play." They're arguing that with these hefty contributions lurking in the background, these judges might not be seeing things clearly. Imagine trying to play a game where the umpire's getting paid by one of the teams. It's not exactly a level playing field. This isn't just a legal hiccup, it's a big deal. It's about the very essence of justice, about ensuring that decisions made in the courtroom aren't influenced by backdoor deals and wads of cash. It's got everyone in the legal world holding their breath, waiting to see if the powers that be will step in and say, "Hold on, something's fishy here." Because in the end, it's not just about Calkins' case, it's about the trust people put in the justice system, about making sure that when the gavel comes down, it's a fair and impartial judgment, not one swayed by bulging wallets. Uncovered allegations. Get ready for the legal bombshell of the century. Picture this, a whopping $7.6 million, not in small change, mind you, but a colossal pile of undisclosed campaign contributions landing in the laps of those two Illinois Supreme Court judges, Rochford and O'Brien. Yep, you heard it right. Millions slipping through the cracks, making folks gasp louder than a surprise plot twist. Now let's break this down. These judges, the ones making calls on the whole rifle and mag ban, might have had their pockets lined with this staggering amount of cash. And here's the eyebrow-raising part. It wasn't some loose change from a street fundraiser. It was from the very folks tangled up in this legal mess. Can you smell the conflict of interest from a mile away? That's the worry right there. When you've got judges handling a case involving those who've slipped them millions, it's like trying to keep a straight face when you've already picked a side. Calkins' team, and pretty much everyone with a sense of fair play, is shouting from the rooftop saying, "Hold on a minute, this ain't playing fair." It's like the referee at a game accepting a giant suitcase of cash from one team's coach and then blowing the whistle. Here's the thing. These contributions weren't just some footnotes on a spreadsheet. They were mammoth, monumental, and were never supposed to be kept hush-hush. Imagine uncovering a treasure trove of gold coins that were meant to be out in the open but were hidden in a secret vault instead. So what's the big deal? Well, these judges, sitting up there in their legal thrones, might have had their judgment clouded by this hefty sum. It's like trying to keep a clear head while swimming in a pool full of dollar bills. Not an easy task.
All kinds of firearms that take detachable magazines.
There's a hearing that you can't be at, your counsel can't be present, you haven't been charged with the crime.
The ATF, before they abolish our Second Amendment rights. Alcohol, tobacco, and firearms
makes it less likely for people to shoot things they are not aiming at.
The last case that they rendered a decision in that was tangentially related to the Second Amendment was in 2016.
This isn't just some legal hiccup. It's a big glaring question mark on the fairness of the entire legal system. It's got everyone buzzing, wondering if the scales of justice for the next episode in this legal drama. Petition for judicial disqualification. Now brace yourself for this legal head scratcher. Calkins' team, smelling something fishy with those hefty campaign contributions to the judges, waved the flag for a fair fight. They said, "Hold your horses, Illinois Supreme Court. Those judges might not be playing fair." So what they do? They asked for these judges, Rochford and O'Brien, to step out of the game, to recuse themselves from the case. But here's where it gets wild. The Illinois Supreme Court, in a move that had everyone scratching their heads, slammed the door on that request. Yep, they denied Calkins' team's plea to disqualify these judges. Can you imagine the legal gasps echoing through the halls? It's like asking for a fair referee in a game only to be told, "Nah, we're good, keep playing." Calkins' gang had a solid point. Those judges sitting up there had received millions from the defendants. It's like saying, "Hey, can we have someone without a direct connection to the teams calling the shots here?" But the Illinois Supreme Court didn't seem to see eye to eye on that. Nope, they said, "Sorry, no can do," leaving everyone scratching their heads and wondering if the scales of justice needed a bit of a tune-up. This ain't just about Calkins' team. It's about the principles of fairness and impartiality in the legal arena. When you've got judges with potential ties to the folks involved in the case, it's like having a team member playing ref. Not exactly the definition of fair play. Now, with this denial ringing through the courts, the legal world's got eyebrows raised and jaws dropped. The big question mark hanging over it all? Can these judges truly make an unbiased call when they've already been tossed a mountain of cash from the very folks they're supposed to judge?
Contrast that with what Republicans did to address gun violence and crime the last time they were in charge.
And they're turning it into 10 days plus a number of steps that you have to take in order to clear your name.
And there's been quite a few amendments. Well, the last thing to happen just happened yesterday.
Do you think we're our safeguard on this one is there's no way that the Supreme Court will allow this, or is...
It's a cliffhanger that's left Calkins' team, and pretty much everyone rooting for fairness, shaking their heads. Because when the gatekeepers of justice won't step aside even when there's a shadow of doubt, it leaves the whole game looking a little murky. Implications for Second Amendment rights. You know what makes this legal showdown a headline grabber? It's not just about some law in Illinois. Nope, it's about the big kahuna of rights, the Second Amendment. Picture this. Calkins' case isn't just about rifles and mags. It's about the very heart of the right to bear arms. So here's the deal. The Protect Illinois Communities Act is throwing punches, saying, "Nope, can't have these rifles or those mags." Calkins' team? They're waving the constitutional flag, shouting, "Hold up, this ain't right under the Second Amendment."
A real Second Amendment case was in 2010 in McDonald v. City of Chicago.
Individuals who own pistol braces, which were originally approved by the ATF themselves.
And every conservative in this Congress to stand with Representative Clyde and his legislation and to stand with me.
Now, you could argue, actually, that the pistol brace makes the gun safer.
And said he supports a ban on the sale of assault weapons, which there's no such thing.
And call on young people to continue leading efforts to end gun violence.
But I guess the other thing, the back door to, well, the assault weapons, absolutely, because there's no definitive...
Why is this such a big deal? Well, the Second Amendment's like the MVP of rights. It's the one that says, hey folks, you've got the right to bear arms. But when a state starts drawing lines around which firearms you can and can't have, it's like testing the limits of that MVP status. Imagine you're an Illinois gun owner, suddenly the state's telling you, sorry, that rifle or mag you've got, not allowed. It's got folks worried that if this flies in Illinois, what's stopping other states from doing the same? This isn't just a legal tiff over some gun rules. It's about setting a precedent. If Illinois gets the green light to say, nah, these firearms aren't okay, it could start a domino effect. Other states might follow suit, putting restrictions on commonly used firearms. And that's where Calkins' case steps onto the national stage. It's not just about one state's laws, it's about the ripple effect. If the Illinois Supreme Court's decision sticks, it could open the door for other states to put restrictions on firearms that folks have been using without any issues. It's got everyone in the legal arena and beyond holding their breath, wondering, will this case set the tone for how far states can go in regulating firearms? Will it redefine the line between gun rights and state regulations? It's a legal puzzle that's got everyone on edge, waiting to see how the big shots at the Supreme Court will tip the scales of justice. Supreme Court consideration. Hold on to your seat, folks, because we're heading straight into the legal cliffhanger zone. The big shots at the Supreme Court have this hot potato of a case on their plates. Calkins' battle against the Protect Illinois Communities Act has made its way up the legal ladder, and now it's sitting right in front of the highest court in the land. But here's the twist that's got everyone's eyebrows shooting up. Illinois, the state tangled up in this whole rifle and mag mess, they're not exactly gung-ho about defending their side of the story. Nope, they're hanging back, sipping on some legal tea and saying, we're not going to dive into this unless the Supreme Court gives us a nudge. Can you imagine the legal murmurings echoing through the corridors? It's like showing up to a court duel and finding out one side's decided to sit this round out. Calkins' team's probably scratching their heads too, wondering what this chess move means. Does it mean Illinois isn't confident about their defense? Or are they playing some strategic waiting game, hoping the Supreme Court steps in and makes a call without them having to say a word? It's got everyone in the legal scene buzzing, wondering what the Supreme Court's next move will be. Will they take the reins and make a call without hearing Illinois' side of the story?
Tearing apart families and making our streets less safe.
But let's just say that you actually did get a permit under the original SB2.
And then 1446 is where they're taking the 3-day default proceed.
Let's see what is the most compelling thing to learn from that case. How many times was this gentleman...
Because Bruin said that that's unconstitutional, so they drafted SB2, which was originally introduced back in December.
Which changes now we have an administration that is desperate to erode our Second Amendment rights.
Or will they give him a nudge, saying, come on folks, you gotta defend your turf? This ain't your run-of-the-mill courtroom drama. It's got the bigwigs in the legal world scratching their heads, waiting for the next episode. Because when one side decides to take a backseat and let the chips fall where they may, it's like watching a high-stakes poker game, trying to figure out who's bluffing and who's holding the royal flush. State of Illinois refuses to defend. Talk about a legal standoff. Here's the scoop. In the ring of legal battles, Illinois has pulled a surprise move that's got everyone wide-eyed. They're not playing ball. Nope, they're holding their legal cards close to their chest and saying, nuh-uh, we're not going to defend this case unless the Supreme Court orders us to. Can you imagine the legal world's jaws dropping? It's like being in a courtroom where one side decides to sit back, cross their arms, and say, I'm out, unless the judge says otherwise. Calkins' team and pretty much everyone with a legal antenna up are probably scratching their heads, wondering what this chess move means. Does it signal a lack of confidence in their defense? Or maybe it's a bold play, hoping the Supreme Court takes the reins and makes the call without them having to utter a single word. It's like a game of legal chicken, with both sides staring each other down, waiting to see who flinches first.
And then there's one that Senator Feinstein just introduced, where it's an assault weapons ban.
They don't care about that fundamental liberty law-abiding citizens in this country enjoy.
Under any administration, would become an ally. It needs to go. We need to abolish.
The impulsive leaders at ATF have once again failed to apply simple logic and reason to their decision-making.
And now the ATF, under the guidance of this administration, is coming to take away.
Because when one side says, not gonna budge unless you make me, it's like a high-stakes standoff where the tension's palpable. This isn't just about Calkins' case anymore, it's about the dance of legal strategy. When one side decides to hang back, it's got everyone wondering what moves the Supreme Court might make. Will they step in and say, hey Illinois, you've got some explaining to do? Or will they let this standoff simmer until someone blinks? It's a cliffhanger that's got everyone holding their breath, waiting for the next chapter in this legal saga. Because when one side refuses to take the stand, it's like trying to solve a puzzle with missing pieces, leaving the whole courtroom on edge, wondering what's going to happen next. That's all for this video, folks. See you next time.